Language and law, clearing the cobwebs. The language used for embryo donation, embryo adoption can be confusing and sometimes overwhelming. Let's explore the terminology in an effort to better understand the verbiage. Embryo donation is a term favored by medical and legal professionals. Embryo donation, embryo adoption is favored by social workers and the general public because it is understood that this is a process of donating living embryos to an adopting couple. Embryo donation, embryo adoption is viewed by social workers as a process with two definitive steps. The embryo donor is releasing their embryos to another family, and the recipient family will become pregnant and give birth to a child that is not genetically related to them. When speaking of the process, those in the social services field typically use the term embryo donation, embryo adoption. By using the full term, it clarifies that this is a process with two steps. The legal process is similar to a traditional adoption in many aspects, as there are legal documents that must be completed to finalize the embryo donation, embryo adoption. In the United States, embryo adoption falls under the legal process of contract law. The legal transfer of the embryo from the donor is considered a transfer of property. Proper informed consents and a legal contract stating specific conditions and terms of the agreement is all that is required in embryo adoption. The adopting couple's names will then appear on the child's original birth certificate, stating that they are the birth parents. In traditional adoptions, a surrender from the birth parent is required for an adoption that includes provisions for a revocation period. In embryo adoption, no revocation period is required. Georgia permits, but does not require, a couple becoming parents through embryo donation and adoption to obtain a court-ordered adoption finalization following the birth of the child, confirming them as the legal parents of the child. Obtaining a court-issued finalization of adoption, the adopting family can then apply for the federal adoption tax credit. Statutes passed in May of 2013 in the state of Tennessee stipulate that the donation agreement cannot dictate any expectations for required visitation or other conditions. Like Georgia, Tennessee adoptive parents may file an adoptive petition seeking a final order of adoption, thus qualifying for the federal tax credit. However, in either state, a final order of adoption is not required. As with all types of adoption, including embryo adoption, there is a wide variation in the relationships between the donor or genetic family and the recipient family. An anonymous relationship occurs when neither party desires to have contact with one another and no identifying information is shared. In choosing a totally anonymous adoption, families may feel that it is a safe option, as they do not have to deal with the other party. However, with time, one of the parties may regret that they did not opt for the opportunity to have an ongoing relationship. For example, if a child were to need a bone marrow transplant and the adoption was closed, they would not have access to needed medical records of the genetic family that would be beneficial in treatment. In some cases, anonymous relationships can be retracted through third-party contact efforts, should both parties be willing. For instance, a counseling intermediary may be able to make a confidential contact that would allow for discussion regarding a change in openness. Still have questions? Call us, email us, or visit our website.